Hello, listeners, and welcome to a new episode of Business Compact, the podcast for founders, seasoned business owners, or everybody else who is interested in learning about the world of international business. In each episode, we will explore topics related to the creation, growth, and globalization of businesses, from founding challenges to international growth opportunities. Our guests will share their insights, personal opinions, and lessons learned along the way, inspiring you to take a closer look at each individual discussed topic. My name is Tobias Kerkhoff, and I'm the General Manager for Internationalization at WannaBe International Business and your host for this episode. I hope you enjoy the upcoming conversation, and as always, if you have any comments, need support for your international business, or want to be on this podcast as a guest too, you're welcome to contact me under my email shown at the beginning of this episode. Finally, of course, feel free to subscribe to this podcast and our newsletter. Joining me on today's podcast episode is Johannes Brand, lawyer, specialist solicitor for international business law and corporate and commercial law, and partner at BUSE, Düsseldorf office. He advises clients comprehensively on corporate law, commercial law, and international business law. Additionally to his advisory work, he enjoys working on litigation and conflict resolution. He studied and worked in 4 different countries, Dublin, Bogotá, Madrid, and Brussels, so I guess he's an excellent conversation partner talking about international business. Welcome, Johannes. It's a real pleasure to have you on our podcast.
Thank you, Tobias. I'm happy to be here. Thanks for the invitation.
Then let's start right away. Could you tell us a little bit more about yourself?
Well, yes, sure. So you've already told the audience quite a bit about me. What more is there to add? So my name is Johannes Brand. I'm a German-based lawyer. I live in Düsseldorf since 3 months or so. Before I lived in Frankfurt. And as you said, I have been, as they say in Ireland, where I also studied, I have been a little bit around the block. I studied in Trinity College Dublin, did my master's degree there before I lived in Bogotá, in Brussels, in Madrid. And I specialize in corporate and commercial law, both domestically and cross-border. Quite a number of my clients is active in international business. Mostly it's commodities producers or sellers. Therefore, I believe or hope that I'm really the perfect match, or at least a good choice for today's podcast.
Thank you for your introduction. Based on your many years of experience as an international lawyer, what are the main challenges for business when they decide to expand internationally? And of course, I'm aware that there are countless challenges. Could you name the 2 or 3 most important ones according to your point of view?
So actually, I would start a little differently, because from my point of view, there is one main legal task or challenge when you decide to expand internationally, and that's who to partner with. We can go a little bit into substance, and I think we will today. What you need to do in substance matter if you're expanding internationally. But I think that the main important task is to find the right partner to do it with, because I would strongly advise against doing that on your own. I think that you need to have someone there on site, so to say, a local lawyer, because that local lawyer is the one who is familiar with the legal framework, who is familiar with authorities, courts, or whatever you need. But then, of course, if we go into substance, I would say that 2 or 3 main topics are corporate setup. I think that you would need to choose wisely which setup you choose. That could be, for instance, in Germany, if we now consider that vice versa, for market entry from a foreign company in Germany, it could be in Germany, limited liability company, it could be a stock corporation. All of these setups have different advantages and disadvantages. And that is closely linked to the second topic, or the second challenge, to choose your tax setup, because I think nobody would argue against that. Money is a quite decisive factor, and the tax setup could cost you immensely if not chosen wisely. And then thirdly, compliance with everything else, mostly, of course, and everybody I think is thinking about that, is employment law or labor law. Then, of course, everything else that you need to comply with, and that can only work with someone on site.
Thank you for sharing these insights with us, and also for adding the importance of working together with an external partner. So let's dive a little bit deeper into the topic of international business law. Of course, there exist different legal systems around the world, civil or Roman law versus common law, just to mention the most famous examples. If you compare civil law, which applies mostly in the European Union and most of the countries in Latin America, and common law, which applies in the United States and in the UK, what are the main differences and what is your recommendation for potential clients? Again, I'm aware that this highly depends on the specific case. There's no one-fit-all solution.
So again, I would emphasize here that you can only do with someone on site, and that if you, for instance, have a trusted advisor here in Germany, the lawyer who you've been working with for many years, he or she will not be able to advise you for market entry in a common law country. Same would apply to me. That's also the reason why I would say I'm not the right person to explain the characteristic or the main items of a common law system. But I can say that from a superficial point of view, there is the main criterion which differentiates both is the common law system, which is based very on case law, and the civil law system, which is based a lot more on written or statutory law. And that makes common law systems a little less predictable, which might sound a little to a lot of people, because they would say that, okay, but the civil law system is also, as we have it in Germany, is also not totally foreseeable for everyone, because we have the national systems, we have the EU framework and so on. So that's also complicated. But then in common law systems, you have the case law, which makes it complicated in a different way. In any case, it is, if you want to tackle it pragmatically, I would say that from a client's perspective, it doesn't really matter a lot if you're expanding to a civil law country or a common law country, because in any case, you would need to engage someone to guide you through the system. And if that system is common law or civil law, it is eventually not you who needs to understand the differences, but your advisor on site who needs to explain you what you need to do.
Totally makes sense to me. Picking up the previous question, in the context of different legal systems worldwide, how important do you consider intercultural competences for your daily work as an international lawyer?
Absolutely. I would even say it's even important for the client as such, but I think that all internationally acting companies are fully aware of that. If you think about a market entry in China or in Japan or in the US or in Argentina, it's everywhere it's a complete different setup from the cultural understanding, the way that you are acting with your potential clients, their business partners, joint venture partners, or whatever there is, whatever you're dealing with. And then, of course, from my point of view as a lawyer, if I consider my task or the task that I am trusted with, if a German client engages me to help them through that market entry in a foreign country, it would be my task to take them by the hand and to speak with our partners that we have in these countries. Also, not only from an intercultural point of view, but also from a commercial point of view, these systems differ, because let's only talk about hourly rates that might differ completely if you go to, let's say, Holland or Italy, or if you go to the UK. So indeed, there are huge differences.
I totally agree. Based on my own experience working as an international consultant together with different people from all over the world, intercultural competences are crucial for doing successful business. So it's not all about the numbers or hard facts. Reading between the lines and being familiar with the local culture, language are key success factors. We consultants don't enjoy the best reputation, even though a good consultant undoubtedly has his or her justification acting as a trusted advisor. I really like the comparison with a doctor or tax advisor. If you don't have any experience or clue about a specific topic, what you do usually is consult an external expert, someone who knows what he's talking about. So why should I invest hours, weeks, or years of my time for research or acquiring knowledge by myself? Besides, you cannot be an expert for 20 segments industry. This is completely nonsense. So I guess that the situation is similar for lawyers, which means that you are regularly confronted with prejudges. how do you convince potential clients of your added value?
That is a very good question, and I think that we could spend hours only talking about that. As I know, both you and I, we are active on LinkedIn and engaged in discussions with the community that we have there. I always like to speak about those prejudices that potential clients or that the community, that everyone else is having against lawyers. One of them is, of course, the underlying tone is that quite a lot of people, as you say, have prejudices against lawyers, and they simply said they are not always happy with the way that they are dealing with their lawyers. From my point of view, what I can advise is that clients consider legal services just as any other commodity or service that they buy. They should consider these legal services as a commodity. If they don't see an added value, they should not buy them. In principle, that means you should consider that completely rationally and commercially. If you think that the person is not worth the $600 or 300 euros or whatever that lawyer is asking, you should not do it. So you should ask them, what is the reason why I should commission you to do those things here? But then on the other side, it should not stop there, because you as a client, you should also always, what is the bonus I get here? Let's consider, for instance, you're buying commodities, spare parts you buy to put them into a machine that later on you're selling. If you're buying those spare parts for too much money, it eventually means that you don't get the margin out of the machine you're selling. So if you're doing the same, or if you're applying that same ratio towards the lawyer services you're buying, it gets a lot easier. Because if you're thinking about what will happen if I don't commission that lawyer, or what will happen if I commission that lawyer, eventually, I think if that lawyer has the same mindset and thinks and understands that, it gets a lot easier. But you need to think about buying legal services as a commodity, as a service.
Sounds familiar to me. Very useful suggestions. Maybe I should use one of them, even though for myself. Next question. A central cornerstone and the legal framework for every business refers to contracts. Just think of labor contracts, supply contracts, or sales contracts, to give some examples. Latin formula and one of the key principles in law, pacta sunt servanda, is not always applied. Or in other words, contracts are not always honored by all parties, which leads to conflicts and can end up in many years of legal proceedings. What is your advice to prevent this case as best as possible?
Maybe even a couple of advice or pieces of advice. So the first thing is, if you are expanding internationally, you need to understand that the idea that we have of contracts as something binding is not a mindset that we have everywhere. This is something that we have maybe in the US, in Europe, but that's certainly not something that we have, for instance, in China, where a contract is, from my experience, rather something kind of an idea of a memorandum of understanding, or so to say. But then eventually it would be taken as an act of aggression if I'm pointing out that in clause 3.4, there's written that and that. This is something that a business partner from China would consider very confusing, because they would say, you cannot be so strict with what is written in the contract, but you need to consider that as an act of faith that we have. And that is certainly also something that we can see if we are expanding to maybe Arabic countries. So that very strict view of contracts, pacta sunt servanda, is not something that we have everywhere in the world. That's something that you need to understand and deal with. Secondly, if you are accepting that, but then you want to have some, or you need to have, maybe from your stake and shareholders, you need to have some more clarity, some more binding character of your contracts. You need to make sure that you have good dispute resolution mechanisms in your contract. If, for instance, you would go to, let's take China, or in principle, every country in the world apart from the EU plus Switzerland and Norway and Iceland, where judgments are enforceable, you must need to think about how you want to settle these disputes, and you would need to think about if maybe an arbitration clause is not possibly a lot better than a court clause, which you can later not enforce, or where you cannot enforce a court judgment. And then thirdly, I would advise to choose your lawyers in a way that you don't have these kind of very formal and strict and aggressive lawyers that go forward and think in legal positions, but I think that you would want to have advisors that are trained in negotiation. I am 40 years old now. I'm practicing law for 10 years. And that is also something that I needed to learn the hard way, because before I thought that, and by before I mean when I started my legal practice, I always thought that it would be the right way to choose the legal framework, to see how's the legal situation and so on. You would spend hours and hours in finding out what actually the legal situation is. You don't have written contract, you have oral agreements and so on. But then on the other side, you see that what is much more decisive is what are the interests of both parties, where are possible win-win situations, what is your leverage that you can use against the opponent, so to say, how possibly can you make of the opponent again a business partner. That is something that is very, very decisive. I can say it from my own experience, not all lawyers think like that, but you would want to have, from my point of view, a lawyer that is skilled in these negotiation tactics.
Thanks for sharing these useful recommendations with our listeners. I hope a lot of them have paid attention, because in the end, contracts affect all of us, not only in the professional life. Just think of rental contracts, lease agreements, and so on. One last question, and I've already mentioned that our industries share a lot of things, not only the prejudices. Another aspect that our industries have in common is that it's a people business. This means that a major part of the success in our business is related to our interaction with clients. For example, building trust, establishing long-term relationships, or an efficient communication. On the other hand, we see that artificial intelligence clearly affects our business already, and in my opinion, will have an even increasing impact in the next years. How do you assess the role of artificial intelligence for your sector?
I do believe that artificial intelligence is playing already a huge role, but not as much as in other sectors where it is already a little advanced. That is definitely in Germany due to the fact that it is a kind of a very regulated market. Not everyone can provide legal services in Germany. There's always a lot of legal dispute and back and forth about the role of AI-based legal service providers. But then eventually I believe, and that is not something I would want to hear in 2, 3, 4, or 5 years, because future might prove me wrong. I believe that as much as AI will change our profession, it will not completely replace the profession that we have as it is. But definitely a lot of work that lawyers are doing today will be replaced. The most simple example is the one of the flight rights. Think about that. A couple of years ago, it was still standard that you would go to a lawyer and tell them my flight was delayed. There's a certain EU regulation that is saying that you get a certain compensation for a delayed flight. A friend of mine did that a couple of years ago, still providing services to consumers for these flight right compensation. This is not happening today, and it's a business that will not come back. That's, of course, completely different to what we are talking about here, B2B businesses. But that thing in B2B context has completely been replaced by AI. And of course, that might happen for a couple of things. Think about contract management, for instance, or corporate setup, including the design of articles of association or so on, contract review. But it will not completely replace the situation that we have, where clients are dealing with their human lawyer, because that, as you say, is a people business, and I think it will stay a people business.
I totally agree. Again, since you've already mentioned consulting as well as international law is a people business, I highly doubt that company owners or private persons will rely 100% on AI, since we have access to very delicate, sensitive information. On the whole, our professions require a lot of integrity, which is something that yet cannot be guaranteed completely by AI. So unfortunately, we have already come to the end of today's episode. Thank you, Johannes, for this interesting conversation about international business law. All the best for you and your next cases, and I hope we can meet soon in Düsseldorf.
Happy to meet anytime here in Düsseldorf. Thank you, Tobias, for having me as a guest. See you soon.